Welcome to this session on TORT. In this session, we look at VNFI, Voluntary Non-Fit Injurer. This is a defense to TORT, right? Let's look at what this means. Essentially, it means you ask for it. Imagine that you've gone to a boxing match, you got hurt, you can't cry and then try and take a legal action because you asked for it. Okay? So let's get started. Before we start, let's go to the whiteboard and see our process once again. It's simple. We have a CLAT approach. First, we'll read the principle, understand the criteria therein. This is very, very crucial. And then read the fact and look at things that are relevant and remove the things that are irrelevant, and then evaluate the options. What is going to happen in TORT is you will have to make a lot of reasoning. It's not going to be as straightforward, right? So, but we'll look at each examples, each questions, and learn from them. Let's get started with question number 1. Let's first read the principle. When a person voluntarily, that is crucial, agrees to suffer some harm, he is not allowed to complain for that. Yeah, so that is voluntary non-fit injurer. Voluntary, he has to agree to suffer a certain harm, then he can't complain. Let's read the facts. A was one of the spectators at a Formula 1 car race being held at Gurgaon on a track owned by one M company. During the race, there was a collision between the two racing cars, one of which was thrown away amidst spectators, thereby causing an injury to A. A claims damages. Damages essentially means compensation for injuries caused to him. Right. There is a legal violation of a legal right, but the question is, let's look at the principle. Did he voluntarily agree to suffer that harm? Now, you'll have to be, what the test is called a reasonable person test. Reasonable from the eyes of the law. In this case, he went to a car racing place, and it is reasonable to assume that there are going to be collisions such as these, and this is a possibility. So in this particular case, he agrees to suffer some harm, right? It is not written anywhere. He did not write it down. It's from the sense of the case we can understand that happened. Therefore, he is not allowed to complain. So is M company liable? M company is not liable. So we'll eliminate the option which says they are liable. Those can be found in A and D. Let's look at B. We have to look at the reason. Okay. M company will not be liable for damages because A had come to see the race on its own will. M will not be liable for damages because the collision between the cars was beyond its control. Now we look at the one that is closest to the principle, and A had come to the race on its own will, that is close, voluntarily agrees, that is close to the principle, and the choice is B. Let's look at question number 2. A person has no legal remedy for an injury caused by an act to which he has consented. He said that harm me, then sorry. Okay, let's look at the facts of the case. A cricket enthusiast purchased a ticket to watch T20 match organized by the Indian Premier League IPL. During the match, a ball struck for 6, hits hard on his body and injures him. He sues IPL for compensate medical expenses. You came to watch the match. People are going to hit a 6. Okay, you can't complain. There is no legal remedy for an injury caused by an act which is he has consented. Now, when you say it's consented, when you've gone to watch the match, okay, from a reasonable person test, it is understandable people are going to hit the ball, sometimes it's going to go outside the boundary line, you've asked for it, right? So therefore there is no compensation. This is what is the principle, applying the principle would mean. Which of the following is the derivation is correct? R should be compensated as he purchased? No. R would fail in action as he voluntarily exposed himself to the risk. Okay, that's the difference. C, IPO would be liable? No. Answer choice is clearly B. So that's the difference. There is no tort if someone has voluntarily consented to it. Okay. Let's look at the next one. Question number 3. As a principle of voluntary non-fit injuria, VNFI, a person who is aware of a risk, 1, and this means plus, this assumes the risk voluntarily cannot claim the damages if he suffers on account of the risk. So fourth thing, he should be aware of the risk, he should assume the risk voluntarily, and he suffers on account of the particular risk. Fair enough. Let's look at the fact. Anand aspires to become a good wicket keeper. Good for you, Anand. And towards this end, regularly attends a cricket coaching camp organized in the Colony Park. Okay, he volunteered to do whatever he's doing. The participants are supposed to bring their own equipments. Raghavendra, the coach, asked him to focus on keeping rather than spin bowling, and he made Anand spend 2 hours daily keeping wicket to leg break as well as off break bowlers. If you don't know cricket, doesn't matter. Some kind of balls. Okay, one day, Arnold, the best leg break bowler in the district, is bowling with Anand at his stumps. Anand unable to respond in time to the sharp googly played by Arnold, and as a result, Anand sustained a serious injury on his left eye. He sued Raghavendra. Let's check the case. Was he aware of the risk? Yes. Did he assume the risk voluntarily? Yes. He was part of the coaching camp. It's going to happen. Did he suffer on account of the risk? Yes. Therefore, Raghavendra, you are safe. Anand, hard luck. Raghavendra, being the coach, should have ensured that Arnold did not bowl such a sharp googly. How can he? It's a coaching camp. Arnold and Raghavendra should be made liable. Whether Arnold should be made liable or not is not coming from the principle at all. Raghavendra can claim the defense of voluntary non-fit injurer. That would be the right answer. Choice D. Anand contributed to the damage by not wearing helmet. Nowhere mentioned the principle. We can apply D to anywhere in the principle. So answer choice is clearly C. Okay, let's look at this one. If anybody voluntarily exposes oneself to the harm suffered, voluntary exposes, that's criteria number 1. He or she is stopped from claiming damages under the law of tort. If you ask for it, you voluntarily do it, no tort. Let's see the fact. Long facts, but let's keep it simple in the sense we'll only look at those aspects of this particular fact which is relevant to the criteria that we are identified, and all we have to figure out is did he or did he not voluntarily expose himself. Okay. Facts. Asif Zeki is a roadside Romeo. One day he was standing beside one of the busy roads. He finds a girl, Megha, dropping a 1,000 rupee note and going off unaware to the other side of the road. She was going inside a college, and Asif wanted to return the amount to her, as he thought the girl might, after attempting to gain her attention for quite some time, he thought of venturing out. Let me read this again. This sentence doesn't make any sense. Okay, she was going inside a college, and Asif wanted to return the amount to her, as he thought the girl might. I know something is missing here. Okay, let's continue anyways. You get the gist of the story, right? After attempting to gain her attention for quite some time, he thought of venturing out and crossing over the road and giving it to her. While attempting to do the same, he hit by a speeding car. He now wants to get compensation from Megha, as he thinks it was due to her that the accident took place. He kept calling her, but she did not respond. Lot of case. Now the issue is Megha. She was a girl, dropped 1,000 rupees note. Mr. Asif took the note and said, "Here's a note, here's a note." She didn't listen. Okay, then he crossed the road, got hit, and now he is suing Megha. So, did he voluntarily expose oneself to the harm suffered? Yes. So he stopped. Yes, so he stopped from claiming any damages. Asif, hard luck. Hopefully she'll return the call one day. Asif will succeed, he will not succeed, he will not succeed. So these two goes. Let's look at evaluate the reason. Whatever is the reason must be in line with the principle. Asif Zeki will not succeed because he should sue the car driver as the cause of accident lies to him, which we don't know. Okay. He took the task voluntarily, and it was his own wrong due to which he got injured. D is the right answer choice because that is closer to the principle. C is not. Let's look at the next one. no man can enforce a right which he has voluntarily waived or abandoned. Same thing, the voluntary non-fit injurer. If he has voluntarily waived or abandoned a right, then it can't be enforced. Principle 2 says, merely because the person knows of the harm does not imply that he is assented to suffer it. Just because I know the harm does not mean I have assented to suffer the particular harm. Two interesting principle. Let's see this particular case. This is actually a very good case. Helps you to understand some of the challenges that we'll face while answering questions on tort. Is that eventually come down to reasoning. Let me explain this fact and help you understand how do you reason when it comes to tort, so that you will not make any mistakes. Let's look at the fact of the case. Suraj and Dheeraj were best friends. They both owned a cart. One day both of them decided to go from the village to the city in their cart. Both of them were aware of the fact that the horse could bolt. So one is, they were friends, both of them owned the cart. So you have Suresh and Dheeraj. Okay, both of them were aware of the fact that the horse could bolt. It was something they were aware of. So Suraj, however, insisted that they should not use the cart as it would be dangerous. Dheeraj, on the other hand, was adamant that they should use the cart for travelling. After some protest, Suraj agreed. Okay, now the case, yes, Suraj said we should not use the cart, but eventually Suraj agreed. On their way, the horse bolted and Suraj was insured. Suraj filed a case against Dheeraj. Now, when we evaluate this kind of case, okay, now Suraj agreed. Was it a voluntary agreement? That is a key thing. Did he voluntarily waive it, or was it involuntary? Now, if you look at this case, and this is where the reasoning is very, very important, they two are friends and they both own the cart. It's not like Mr. Suraj was a servant of Dheeraj. Okay, they both owned the cart, so they were friends. When Suraj agreed, he voluntarily waived. He could have said no, there was no harm, he's not going to lose the job or anything in this case. So will Suraj succeed? No, he won't. You get the point? Had Suraj been a servant of Dheeraj, then the case would have been slightly different. In this case, both were owners, right? This is the kind of reasoning that the tort will challenge you, or the questions on tort will challenge you. So in this case, Suraj will not succeed. Okay, let's look at which option to mark. Suraj will not succeed. So Suraj will succeed is wrong. Will succeed is wrong. D and goes. Suraj will not succeed. So we'll have to evaluate the reason. As he was aware of the fact the horse bolted, because he was the owner of the cart, he could have refused to take the same to the city. This is the crucial thing. Between B and C, why is it C? Because I'll tell you why. It's not because of awareness, because of principle number 1, which says voluntarily waived. Okay, so therefore it is this reason which talks about voluntarily waiving it. He could have refused it, he did not, volunteered. So option C is the right answer choice. We looked at a couple of questions which are little tricky ones. Please assure you will find more such questions which forces you to do a certain set of reasoning, and we'll do that in the next set of sessions. For the time being, goodbye.